Hi everyone, and welcome to a real estate educational series with Anna Stevchenko. I'm a real estate professional from Miami, Florida, and decided to create this series with two main purposes: educating and informing my audience on basic yet very essential real estate topics. Today is the second episode of the Real Estate Educational Series with Anna Stevchenko. In today's topic, we will be discussing the nuances in the sales contract. As we all know, the sales contract has so many clauses and contingencies that sometimes are very tricky and therefore must be paid extra attention to. To obtain answers as per what such nuances are, I came to the offices of Andrew Tarr, a renowned real estate attorney with over 26 years of experience, who graduated the University of Miami and whose practice involves anything that has to do with real estate. Hi Andrew, how are you?
I'm doing well, Anna. How are you?
I'm doing great, and once again, thank you so much for taking the time and doing this interview.
My pleasure.
So based on your professional experience, what are the most important nuances of the sales contract that buyers and sellers should pay extra attention to in order to have peace of mind and make sure that the deal closes successfully?
Sure. So it might be helpful for your viewers out there to understand a little bit about the contract itself. What we use is called the FAR/BAR contract. It's actually two contracts that you can use, but the preferred method in probably 95% of transactions is the FAR/BAR contract. It's a contract where the Florida Association of Realtors, that's the FAR, and the Florida lawyers, that's the BAR, get together about once every year and they discuss different nuances and different problems that people have experienced in the last couple of years with the contracts and how can it be improved. Most importantly, the FAR/BAR contract is very fair to both sides. It doesn't take sides, it's not pro-seller or pro-buyer, but there are certain provisions, as you indicated, that could make it a little bit more favorable towards a buyer or towards the seller, things that I might look at depending on obviously who I'm representing.
Sure. So what are they? What is the most common nuance that you would like to discuss with our audience today?
Okay, so lien searches, title searches, different costs that are associated with closing a transaction. And without getting into too much detail as far as what they are, but both of those, lien search and title search, tell us that the property is good. It's free and clear. There aren't any problems that is going to cause a potential problem for the buyer in the end. And that's a charge, it's a cost. So who pays for that? There are provisions in the contract that can indicate who's going to pay for that. So also related to those would be the actual title insurance itself. Now, title insurance is not like regular insurance where you have to pay it on an annual basis. Title insurance is something that's a one-time purchase when you purchase the home, and it insures you for the lifetime of your ownership of that property. And what does it do? It ensures that nobody's going to come out of the woodwork later and give you a hard time or make a claim against the title that you now have to your new property. This could be old heirs to an estate if the property had not been properly probated. It could be judgments, people who haven't been paid. There's all sorts of problems, but a good lawyer and a good closing agent like what we do is we make sure that those problems never creep their ugly head into your transaction and into your history of owning the property. So the title insurance is a one-time purchase, and we make sure that you're not going to have any issues. We do all the homework and the research and the hard work up front.
Sure.
So that when you come to the closing table, you can have the peace of mind of knowing that your property is your property and nobody's going to interfere with that right, title, and interest to it.
So what a lot of buyers ask me is, what happens if something didn't pop up before closing in the lien search or title search or in the permit search? So what happens if something shows up later on and they are stuck with it?
Okay, good question. Well, if it's something that title insurance would cover, then the title insurance company would step in and they would defend any claims that somebody who's coming out of the woodwork might make a claim on the property. So if they have a lawful claim, the title company, title insurance company, underwriter is actually going to adjust that claim. In an absolute worst case scenario, it could mean that you lose your property, but you don't lose your investment because you're insured for the value of what you paid for the property. Now, this is a very unlikely scenario. I want you to be sure. Yes, it could happen, but it's a very, very remote chance, and we take all precautions before the closing to make sure that nothing like that is going to happen. But of course, the whole reason you have insurance is just in case. So it's a just in case scenario. It's a one-time purchase. It's not an annual thing like a homeowner's insurance or your car insurance that you might be used to. There's no deductibles that you might have to pay. It's just a premium that you pay at closing. And that premium is promulgated by the state of Florida. Simply look at the purchase price and it tells you how much the title insurance is. Off the top of my head, for example, I know if you're buying $150,000, it's $825. The rates have calculations that are specified by the state, and that's what we go by.
Absolutely. And let's talk a little bit about the seller's disclosure. When the contract is executed by both parties, we sign a lot of additional paperwork, and one of them is the seller's disclosure. Can you please point out the importance of such disclosure to be delivered to buyers?
Well, buyers want to know what they're buying, and they have a legal right to actually know that. And that could be something as crazy as deaths on the property. Something that would matter to a buyer should be disclosed by a seller. That's the best and easiest way that I can explain that. And the seller's disclosure, which you're talking to, tries to encompass anything that the buyer might want to know, any latent defects, known or unknown. The seller has an obligation to tell the buyer, so the buyer can make an informed decision. And this is contrary to what we call caveat emptor, which is buyer beware. We don't really have that anymore. We have a situation where the sellers have to tell the buyers, and if they don't, then the sellers could be held liable even after the contract closes for something that they should have disclosed, but they didn't.
Absolutely. And in the very end, what other addendums or disclosures would you recommend to both parties of the contract to sign at the time of executing the actual contract?
Good question too, and I think we touched on this on an earlier interview that we did, but the condo addendum, for example, and the condo addendum shifts responsibilities for each party and could actually involve significant financial consequences. For example, if it's a condominium and the condominium has a special assessment, who's going to pay for that special assessment after closing? And there's different places that you can check off, whether the buyer, for example, is going to assume those charges once they assume ownership of the property, or is the seller going to be required to pay it in full prior to closing?
Sure.
These are all things that you need to negotiate in the beginning of the contract. Now, one thing I want to point out, because you might be asking, how would a buyer know? So how would they know to negotiate that? Well, it's very simple. It goes back to that whole disclosure that we were talking about. The seller has to tell the buyer whether or not there's a special assessment coming down or already passed.
And in my opinion, it's also a big responsibility for the buyer's agent in particular to obtain information directly from the condo association in regards to the upcoming special assessment, because sometimes the sellers don't even know, and then surprise.
I'll give you another surprise, and this is true, and some people don't really realize that the standard real estate contract calls for this. So it's not a matter of whether or not the seller knew that there was an assessment.
Absolutely.
It's not even important that there actually is an assessment. What the contract actually says is that you go back a year, and if the board of directors has even discussed an assessment, because the buyers don't know, but the sellers get the minutes of these meetings, and they're charged with the responsibility of reading to know what's going on at these meetings. I'm not suggesting they actually have to go to the meetings, but they probably
At
should.
least keep track of the minutes.
They need to keep track of what's going on. So if they've discussed, here we are in June, for example, but last November they talked about doing a special assessment to repair balconies, and it's in the minutes, and then they subsequently passed this special assessment, that's something that the seller would be responsible for because they didn't disclose it to the buyer.
That's a very important part. Actually, thank you so much, Andrew.
Sure.
And in the end of the interview, could you please give major key points to buyers, sellers, realtors as per what nuances they should pay attention to when signing the contract?
Sure. The contract has different check marks, if you will, for who's going to pay for certain things: title search, lien search, title insurance, for example, estoppels. And from my perspective, it's always smart, if the buyer is paying for the title insurance, the buyer should be selecting the title agent. And it's probably in the buyer's best interest to be doing this anyway. And the reason why I'm mentioning this is, as you know, in Florida, it's the seller who actually pays for title insurance, except in Miami-Dade and Broward County. And the standard FAR/BAR contract that we talked about has a specific provision that's called the Miami-Dade Broward Regional Provision. And we're different.
We are very different.
Yeah. And I think it's better, frankly, because I think the buyer should be paying for their own title insurance and not relying on a policy that the seller is going to give them. Because let's face it, this is the seller's people.
So, yeah, exactly.
Yeah, you should know what's going on and basically take charge. It might be a little bit more expensive, but in the grand scheme of things, when you're buying, property that could be hundreds of thousands of dollars, $1,000, $2,000 for title insurance is a drop in the bucket. And again, it's a one-time purchase.
Andrew, thank you so much. It was very valuable. Thank you, dear audience, for watching the Real Estate series with Anna Stepchenko, and we will see you soon. Bye.
Buying and selling real estate is an important decision that you should not undertake on your own. Please feel free to call me at any time throughout the process for a free consultation and to see how I can help you and probably save you some money.